Okay, so it is 12:02, so we are going to go ahead and jump right into it. I do just want to briefly mention that in the chat, I have a message pinned. That's a link to a Google Drive file. So if you want to open that, it's downloadable, and it just kind of covers a lot of the terms that are going to be discussed today. So that's something that you could keep and maybe reference later if you want to. But we are going to jump right into it. Welcome, everybody. My name is Royce, and I want to thank you all for coming. Welcome to the Estate Planning Essentials, Last Wills, Trusts, and More virtual webinar. We have a presentation that is going to last around 45 minutes and for a Q&A. So if any questions come up while the presentation is going, feel free to jot them down, or you could go ahead and just throw them into the chat, and we will address them at the end of the session. Today's speaker is Evelyn Sylvester of the law offices of Evelyn B. Sylvester. She is a solo practitioner in Manhattan with over 7 years of experience as an estate planning attorney. So without further ado, I'm going to hand things over to Evelyn.
Thanks so much, Royce, and welcome everyone. I am Evelyn Sylvester, and this presentation is titled Estate Planning Essentials, Last Wills, Trusts, and More. So before we get going, just a brief disclaimer. This presentation and any accompanying materials are for informational purposes only and are not intended to provide, nor should they be relied upon as legal advice. In addition, know that laws and regulations can change often, so this information contained herein is accurate to the best of my knowledge as of the date of this presentation. And today's agenda. We are going to cover the elements generally involved in a foundational estate plan. It will be 6 topics. First is financial power of attorney. Second is healthcare proxy. Third is guardianship. Fourth is wills. Fifth is revocable living trust. Sixth and final will be Medicaid planning. Each of these documents is a tool in estate planning, and we'll discuss what each tool does and why it's necessary. I want to take a step back to mention I've likened the estate planning documents to tools because they are tools to achieve estate planning goal. Not all tools are created equal, so clients have unique circumstances. So using right estate planning tools with the right tailoring for their unique circumstances can make a big difference in terms of how effective those tools are going to be. Now, I want to demystify what an estate planning is. The term estate planning tends to conjure up images of a practice that only pertains to wealthy individuals. But this simply isn't true. What will happen to your assets when you pass away? Even if the amount of the assets you own isn't impressive, it's still important to go through the process of planning your estate so that it passes to those you desire. If you don't plan your estate, then the government will decide for you who gets what. Plus, if you have considerable assets and don't use estate planning techniques to avoid estate taxes, the government gets a hefty chunk of it as well. Is that what you want? Your estate plan may be simple as a will that denotes the beneficiary of your assets. It might be complicated and include several trusts for varying purposes, plus your will. So, what is estate planning? Estate planning is the proactive process of planning for life events, both the expected, such as going overseas on vacation, and unexpected, such as getting hit by a bus, lying in a bed, comatose. And also inevitable, such as death, which is inevitable for every living thing, though the exact timing and circumstances may be unexpected. A will or trust is foundational, but it's not the whole picture. A comprehensive estate planning includes other critical documents like power of attorney, healthcare proxy, living will, disposition of remains, and a detailed record of your assets and liabilities. Together, these tools ensure your personal, legal, and financial matters are handled the way you intend, both during your lifetime and after death. The following are some of the tools commonly involved in an estate plan. Now, some of these tools are only effective during the lifetime of the person who created them, and some are effective after death. Others might be effective both during life and after death. And this chart shows at what point in time they are effective. Now, financial powers of attorney are only effective during the lifetime of the maker and cease upon your death. Healthcare proxy, on the other hand, are primarily effective while the person is alive, but they may also be related after death to authorize an autopsy, or they might express wishes or directions regarding the disposition of remains, such as burial or cremation. As you may guess, guardianship documents are only effective during life. Last will is effective upon death, but living trust, as the name denotes, are effective during life and after death. Now, earlier, I promised that we would jump into each of these foundational estate planning elements one by one. Let's start off with financial powers of attorney. Powers of attorney, or shortened form POAs, is a legal document enabling you to appoint a trusted person to make financial decisions on your behalf when you are unable to do so. Now remember, they relate to asset management and financial decision-making during the maker's lifetime. There are different types of powers of attorney depending on the timing and scope. Powers of attorneys can be based on the timing, springing, meaning the power springs upon a specific future event. For example, the incapacity of the maker. It can be durable, meaning that the powers are effective immediately once the maker signs them, and most importantly, survive the incapacity of the maker. Springing is often used to prevent early abuse of power, while durable is favored for immediate, convenient access and manage finances without delays. As for the scope, they can be general or they can be limited. Powers of attorneys can be general, which gives the agent broad authority, or they can be limited in scope, giving the agent limited powers or authority over certain specific assets to sell a particular real estate or a particular type of transaction. In New York, all the powers of attorneys are durable unless specifically expressed in the modification section. In New York, statutory short form is widely used. The execution requirements must be signed before 2 witnesses, dated and acknowledged before a notary. Agent must also sign before a notary, which is called the acceptance. The power of attorney becomes effective on the day the agent accepts the. Now on this slide, you'll see a sample portion of the New York statutory form power of attorney. And you can see that the maker filling these out can initial any of these lines or simply initial line P and state A to O to give all the powers. If you take a moment to look at all these different powers, it seems like an awfully thorough list, right? We have got real property, we have got tangible property, business, insurance, and tax matters. Maybe you're thinking, well, Evelyn, weren't all the powers included in that section? The answer is no. In New York, it isn't included in this one-size-fits-all statutory form. So what do we do to include any powers that you like? In New York, This becomes handy through the modification section. Now you can include any powers that you want, such as handling digital assets or appointing guardians, just to name a few. Finally, just some practical advice. Financial institutions may also have their own powers of attorney they prefer to honor. And as long as those forms do not revoke any of the powers of attorney, you can fill out your bank's own forms. Just to check in and summarize, now, without at least a durable power of attorney, a loved one seeking to assist an incapacitated person will have to go to court to get the authority in a proceeding that's generally known as a guardianship proceeding, which I will explain later in my presentation. Now let's move on to discuss health-related documents. Today, I want to walk you through 4 essential documents that protect your life during your lifetime, not after death, but when you are alive and unable to speak for yourself. These are healthcare proxy, living will, HIPAA authorization, and a MOLST form. Think of these as your voice when you cannot speak. Remember Terry Shivo? Her loved ones had to fight to remove certain life-sustaining treatments. Now, the purpose of these health-related documents is to ensure that these sort of situations don't happen. First, the healthcare proxy. The healthcare proxy is one of the most important documents you can have in your wallet. It allows you to appoint someone you trust, your agent, to make medical decisions for you if you lose the ability to make those decisions yourself. For example, if you're unconscious, your agent steps in and speaks with the doctor on your behalf. This document is powerful because it gives flexibility. Life doesn't happen in a script, and your agent can respond to real-time medical situation based on what they know about your wishes. Without a healthcare proxy, your family have to go to court to appoint a guardian, which can be time-consuming, expensive, and stressful. So, healthcare proxy answers one key question. Who do you trust to make decisions? The signing requirement needs 2 witnesses. Next is the living will. While healthcare proxy answers who decides, the living will answers what you want. A living will outlines your preferences regarding life-sustaining treatment, things like ventilators, feeding tubes, and resuscitation. It typically applies in serious situations when you are terminally ill or permanently unconscious. The document serves as a guide for both your healthcare agent and your doctors. It removes the guesswork and reduces the emotional burden on your loved ones. Instead of your family wondering, what would she have wanted? You are already made that clear. So, the living will ensures your values and wishes are honored. Signing requirement. Because of the seriousness of this document, it needs to be witnessed and notarized. Next is HIPAA authorization. Who can access your information? Under federal privacy law, medical providers cannot share your health info, even with close family members. A HIPAA authorization allows you to designate individuals who can access your medical records and speak with your doctors. This is important not only in emergencies, but also for day-to-day ongoing care. For example, your spouse or child may need to call a doctor, discuss treatment, or review test results. Without this document, they may be denied that information. So, HIPAA answers the question, who is allowed to get information about your health? The next is MOLST. MOLST form which stands for medical orders for life-sustaining treatment. This is different from the other three documents because it's a medical order signed by a physician. All the other three documents were signed by you, but this is signed by your doctor. It's typically used for individuals who are seriously ill or medically frail. The most form gives specific instructions about treatments such as resuscitation, intubation, and other life-sustaining measures. So now you might be thinking, wait a minute, don't the living will and most basically do the same thing? So why have both? Not exactly. While both documents deal with end-of-life care, they serve different roles. A living will is where you express your wishes, what you want or don't want. A most, on the other hand, is a medical order signed by a physician. Example, if a patient has a DNR or do not resuscitate order on a most form, EMS is required to honor it. To summarize, the healthcare proxy answers who decides. The living will answers what you want. The HIPAA authorization answers who can access information. And the most provides medical orders for serious conditions. Together, these documents ensure that your voice is heard, your wishes are respected, and your loved ones are not left guessing during difficult times. If you take one thing today, it's this. Having these documents in place is one of the greatest gifts you can give your family. Now that we have talked about planning tools like POAs and healthcare proxies, let's look at what happens when no plan is in place or when these documents are not sufficient. That's where guardianship comes in. Today, I will focus on guardianships for older adults and not guardianship for minors. So what is guardianship? Guardianship is a legal process where the court appoints someone to make decisions for an adult who is unable to manage their personal or financial affairs. Let me give you a quick example. An older adult never signed a power of attorney or healthcare proxy. So their child notices unpaid bills and declining health, but no legal authority to step in. At that point, the only option is to go to court, which could have been avoided with proper planning. Guardianship is a last resort, so it comes into play when someone has not planned ahead or when existing documents like power of attorney or healthcare proxy are not working. It's also used in situations involving dementia, exploitation, or family disputes. In New York, this is governed by Article 81 of the Mental Hygiene Law, and it's designed to be flexible and tailored to the individual's needs. New York uses a functional standard to determine incapacity. This means the court looks at what the person can and cannot do, not just a medical diagnosis. The key question is, can this person understand and manage their affairs? And are they at risk of harm if no one steps in? The court can appoint a wide range of individuals as guardians, such as family members, or a neutral person if there are family disputes. We have two kinds of guardians, personal needs and property management. Personal needs guardian takes care of healthcare decisions and living arrangements, while the property management guardian will take care of paying bills, managing assets, and prevent financial exploitation. The key takeaway is, with the right documents in place, like healthcare proxy and power of attorney, you can often avoid guardianship entirely. The best approach is proactive planning to preserve dignity, independence, and family harmony. Now that we have discussed life planning documents, this is a natural point to transition into the classic estate planning document that most people think of, the last will and testament. Let's take a closer look at how a will works and why it's such a critical part of any estate plan. The will is the legal expression of your desires for the disposition of your property after death. The person is usually called an executor who oversees the estate. Now, a will is effective upon death and it's submitted to probate. Probate is a name for the court-involved process for transfer of assets after death. As I mentioned earlier, the person who creates the will is generally referred to as a testator if male and a testatrix if female, or the testator is often used as a gender-neutral term. The process of a will-based plan is that a testator or testatrix creates a will. The primary job of the will is to set out who gets what after the testator's death. Now, some vocabulary. These distributions are usually called bequests and go to your loved ones called the beneficiaries. The will could specify that certain bequests pass outright, so it's an outright gift, or that certain bequests might pass via trust or otherwise. The will names the executor and his job is to marshal assets of the testator, wind up affairs, and effectuate a distribution plan. Generally speaking, the will is submitted to court and goes through the probate process. Again, probate is the process of court oversight of an estate and a winding up of affairs. In New York, it can be extremely time-consuming, taking up to a year, or extremely expensive, meaning that there are probate fees depending on the value of the estate. Now, in New York, trust-based planning is the standard form of practice because, unlike will-based planning, trust-based planning avoids probate fees, while will-based planning generally does not. A will generally does not avoid probate. So, why would you do a will at all? Well, without a will, assets would be distributed outright according to the laws of intestacy in New York. Now, an intestate just means without a will, and the person who manages the estate is called the administrator. In New York, it generally prioritizes family members such as spouses and children, then parents, then siblings, etc. So, you cannot make gifts to charity or your friends if you don't have a will. All right, some people on this webinar might be thinking, well, those are the people I want to benefit anyway. So what's the problem with intestacy? Well, even if those are the people you want to benefit anyway, it might be that they also want to do some additional planning, or that they would be better served from a tax perspective or an asset protection perspective by doing some additional planning. What do I mean? Well, for example, most parents want to be sure that if they die, their children are provided for. If they have young children, they might prefer that those children end up with trusts that can be managed for the benefit by someone else, as opposed to, say, an outright distribution at the age of 80. For beneficiaries who may have other concerns like substance abuse, an inheritance managed for them in a trust is more appropriate vehicle. Now let's dive into how do you draft and sign a will. First, there must be testamentary intent. This simply means that the document is intended to function as a will. The testator, the person making the will, must understand that they are creating a document that will dispose of their property upon death. Second, the testator must have testamentary capacity at the time the will is executed. This requires that the testator understands three key things. One, the nature and extent of their property. Two, the natural objects of their bounty, meaning their family or beneficiaries. And three, how the will distributes their assets. Third, the will must be executed freely. The testator cannot be under duress or fraud or under undue influence. In other words, the decisions reflected in the will must truly be their own, not the results of pressure or manipulation. Fourth, the will must be properly executed. In New York, this requires that the will be signed by the testator in the presence of at least two disinterested witnesses who must also sign the will. And finally, although not strictly required for validity, wills in New York typically include a notarized self-proving affidavit. This is important because it allows the will to be admitted to probate without requiring the witnesses to testify in court, which streamlines the probate process. Now, when an estate plan is based on a standalone will, it's called a last will and testament. When an estate plan is based around a trust, and I keep teasing the idea of a trust, a will is still part of the complete estate plan, but the will is called a pour-over will. In the event that you die leaving assets in your name, pour-over will transfers all assets into the trust. There is also something called a codicil, which is an addition or a supplement to a will that modifies it in some way. To check in, what's important about a will? With or without a will, probate is likely to be required. Absent a will, assets typically will be distributed via intestate distribution to the people identified by New York state law. At this juncture, I would like to digress and say that assets could also pass in other ways to avoid probate, such as transfer on death designations or via survivorship rights associated with joint ownership. I'm not going to get into those today, but for completeness, I did just want to mention it. I've teased a couple of times, and now I'd like to talk about a revocable living trust. As I have said earlier, a trust is a fiduciary arrangement that allows a third party or a trustee to manage assets on behalf of one or more beneficiaries. So you need three persons. First, the grantor who creates a trust. Second, the trustee who manages the trust. And the third, beneficiary to benefit from the trust. The assets in the trust are sometimes called the trust corpus. Okay, what did I say and what does this really mean? I think sometimes an analogy is helpful. To think about a trust as being like a bucket or basket. The trustee is the one who holds that basket and manages the stuff in the basket for the benefit of the beneficiaries according to the rules that are set out. Another option is to think of a trust as being like a car. The trustee is the one who holds the keys, meaning that trustee is in control, but the trustee has to drive the car along a pre-planned route the trust maker has set up. So there are rules. The trust is a set of rules, and the trustee is the one who manages the assets according to the rules. Now, In order for the assets to come under the management of the trustee, they have to be added to the basket, or they have to be loaded up into the car. That process of putting the assets in the basket or loading them in the car, that's called funding. Funding a trust can be an involved process. For example, it might involve retitling various assets like bank accounts. It can involve preparing and filing deeds for real property to pull the home within the terms of the trust. Now, earlier I mentioned a pour-over will, and I said it's a special type of will that accompanies a trust-based plan. What the pour-over will does is it pours any assets that got left outside the basket or that got left out of the car into the trust upon the death of the trust maker. Trust can be classified in various ways. One way to classify is living and testamentary. The other way to classify is revocable and irrevocable. What does that mean? For example, if a will was my primary estate planning document, my will might direct the establishment of a trust for the benefit of my young child upon my death, because he's too young to be able to inherit outright and manage my money responsibly. The trust that springs into being under the terms of my will, that's a testamentary trust. They become effective when I die. On the other hand, if you create a trust during your lifetime, it generally takes effect right away once it's signed and funded. Trust can be either revocable or irrevocable. A revocable trust is flexible. You can change it, update it, or even cancel it during your lifetime. An irrevocable trust, on the other hand, is much harder to change once it's set up. You would have heard about revocable living trust, or popularly known as RLTs. That's a trust people often create to avoid probate. As the name denotes, you create it while you are alive, and you also can update it as much as you want. Oftentimes with RLTs, the trust maker is also the initial trustee. For example, rather than owning my home as Evelyn Sylvester, the individual human person, I might own it as Evelyn Sylvester, trustee of the Evelyn Sylvester Revocable Living Trust. So in this case, I am the trust maker, I am the trustee, and I am the beneficiary. I can handle all three affairs when I am capable. I hold the keys and I'm in control. I can change the rules of my trust as much as I want while I'm alive and well. If I get hit by a bus or fall into a coma tomorrow, my successor trustee steps in, gets the keys, and takes over. The same thing would happen if I get hit by a bus and died. The successor trustee would step in, get the keys, and take over the management of all the trust assets. Another important aspect is that a revocable living trust is effective both during lifetime of the trust maker and at the death of the trust maker. So the major take home here is that a revocable living trust does not provide any asset protection for the trust maker. I want to repeat that because that's very important. A revocable living trust does not provide any asset protection for the trust maker. It can be structured to provide asset protection for beneficiaries, but it will not provide asset protection for the trust maker. On the other hand, an irrevocable trust may provide asset protection to the trust maker and certainly can also structured to provide asset protection to the beneficiaries. Remember, an irrevocable trust generally cannot be easily changed. To check in, why And when would a client want a trust-based plan or a will-based plan? Absent a trust-based plan, assets are going to be subject to probate. Probate can be time-consuming and expensive and public. A trust, on the other hand, allows greater privacy and also particularly useful in situations where there may be family disputes. Now that we've discussed all the tools and importance of planning, let's turn to one of the biggest concerns families face: how to pay for long-term care. That's where Medicaid comes in. This presentation is not complete unless we dive into the salient features of Medicaid. As you may know, Medicaid is a public health insurance program designed for individuals who meet certain eligibility requirements. The biggest myth is it's for the poor. This isn't true. An individual has to fall under certain category, such as SSI recipients, disability recipients, medically needy claimants, elderly, blind, or the disabled. Elderly means over the age of 65, and many of you may qualify under that category. Additionally, you need to be a US citizen and have New York State residency. A new exception has been added for undocumented immigrants over the age of 65. In addition, to qualify, Medicaid has a strict income and resource limits. For a single individual, the asset limit is roughly around $30,000, though this number is adjusted periodically. Medicaid covers 3 provider services. First, community Medicaid is when you live at home and still get Medicaid for doctors or hospital visits. Second, long-term home care is you are still at home but cared 24/7 by a home attendant. From September 2012, these are covered by Managed Long-Term Care, shortened MLTC, which you have heard about. Third, institutional care is where you are admitted to a nursing home. At this point, many people start to feel a bit overwhelmed and may think, how can I possibly qualify for Medicaid if I have too many assets? That's a very common concern. In order to be eligible for Medicaid, you need to dispose excess resources. First, the applicant may simply spend the resources down for his or her own personal benefit. New York is a spend-down state. Second, if the applicant has incurred necessary medical expenses, these expenses cancel out excess resources. And finally, in certain situations, excess resources may be transferred to another individual, such as spouse or a disabled child. When it comes to transferring assets, timing is critical. Medicaid reviews financial transfers made within the past 5 years for institutionalized patients. If assets were transferred for less than fair market value, a penalty period is imposed, meaning Medicaid will not pay for care during that time. This is one of the most important rules in Medicaid planning. So, why would we plan for Medicaid? Because nursing home costs from $12,000 to $15,000 a month, home care can also be costly. Without planning, assets will be depleted rapidly. There are several legal strategies used in Medicaid planning. These include transferring assets into an irrevocable trust called Medicaid Asset Protection Trust, which is often formed MAPT, which is very complicated and beyond the scope of this webinar. Should you wish to do any trust planning, please contact me after this webinar. Last but not least, while Medicaid helps cover significant costs, It's not entirely free. Individuals may need to contribute part of their whole income. Or if you receive a personal injury settlement, you need to settle Medicaid debt with Department of Social Services. And New York State may seek repayment after death. So one of the biggest misconceptions about the home is when you are alive, your primary residence may be protected. But after death, Medicaid can seek reimbursement through estate recovery. This is why proactive planning is critical if preserving the home is your goal. The key takeaway is simple. Medicaid planning is most effective when done early. With the right plan, you can protect your assets, preserve your home, and ensure access to quality care. Now we are done with the presentation. The next 15 is allocated to questions. And thank you very much for joining me. If you'd like more information, please don't hesitate to reach us at evelyn@evelynsylvesterlegal.com. Thanks again.
Perfect. Thank you so much, Evelyn. So very briefly, I just want to mention that in the chat, for those of you who may have missed it, I posted a link to a Google Doc that's downloadable. It just covers a lot of the terms that we went over today, kind of like a little bit of a cheat sheet if you want to reference this back at any point. But we are now going to move into the Q&A. So if anyone has any questions.
I have a question. Can you hear me?
Yep,
Yes,
I hear you.
yes, we can.
First of all, thank you, Evelyn. Thank you so much. And the question is, will we be getting any of these slides? Because this is so much to take in. Will we be getting any of these slides or this recorded? Is this presentation being recorded?
Yes.
So we do have the presentation. We are happy to send you the slides. Also, the cheat sheet does go over a lot of the content, but yes, we are happy to send you the slides.
Yes, please. We would like it as well.
Yeah,
Well,
no problem.
yes, sure.
same
But
here.
is it possible to get a recording of this? Has it been recorded? It looks
It
like
has. Sorry.
it looks like it has been recorded.
Yeah, it has been recorded. Yeah. Yeah, we could look into something that out as well.
I need a recording of this. That would be very helpful. And and the slides. But Evelyn, you talked about spending down for Medicaid. Well, how do you spend down if you have a pension and an annuity?
When you die.
How do you spend down from
Yeah, pension.
a pension? Because that's a fixed income.
Yeah, that's income. So you have to do a thing called pool trust. So you have to transfer your income into a trust called pool trust. But when you transfer your income into a pool trust, you can spend the money you are transferring into the pool trust for certain expenses like rent and rates, your utility bills. But at the end of the day, when you pass away, if there are any balance, you are not going to see anything. It's the pool trust is the nonprofit organization who is managing the pool trust. They take it. That's unfortunate. That's the,
Well, who do you get in touch with to have a pool trust?
There are zillions of organizations, nonprofit. I can send you a list if you want to. Yeah, sure. Yeah.
All right. So I
that,
think,
yeah.
And does that mean that I would have to put all of my income into the pool trust?
Yeah, it has to be transferred as you get it, every month or to that effect, because even $1 excess on these excess resources will not, will forfeit you from getting Medicaid. So everything has to be transferred. And there is very specific, it's very, there's these nonprofits who deals extensively with that, and based on your situation, specific situation, we can see which one caters to your needs and then join.
Would they pay the bills then?
Yeah, yes, absolutely. The bills, any bills that can be paid as much as you want, the bills like utility bills, rent and rate. There are very restricted.
What
Although,
if I want to buy clothes, something more luxurious, more on a luxury basis? Would they pay those bills too? If I want to buy
Um,
clothing?
should like, if it's a day to day, right? Yeah. So we have to check with the specific, I think, non-profit to see whether they will.
Well, if you'd send me, I don't know how you're going to do that, but if you could send me anything on the pool trust, that would be very wonderful.
Yeah, sure.
Again,
That's
you're left with nothing. You don't have any money at all. It all goes into the pool trust,
Yes, that's the unfortunate part of.
but they
So the
pay all
best
your
bet,
bills.
yeah, the best bet is for you to be healthy as much as you can, but you never know what will happen in the future. So, but you need to be proactive in healthy, so you don't end up in a nursing home. There's a difference. I told you there's a difference between community Medicaid and nursing home Medicaids. So the nursing home is where you look back for 5 years, 5-year look back, and then so even home care, it's so you need to be, so the more you're proactive in taking care of your health, that's what I would say at this point. Even I think about it, how can anyone, you end up if you transfer everything into the pool trust, unfortunately you're not going to see anything, or none of your beneficiaries are going to see anything out of it. So that's
Oh,
that's
you went. Oh, I see. You no longer have a way of leaving anything to your beneficiaries once you put it in the pool trust.
yeah, that's pool trust. But when it comes to, if you have resources, you can transfer it. So earlier the better, not earlier, right timing, like, if you're in the 60s, no, if you're in the 70s, 60s also, you might think, hey, I will, if you are, say, dying 85, you might think, I'm very healthy, so why would I transfer it? Because once you transfer it into a trust called MAP, Medicaid Asset Protection Trust, and if it's 5 years past, no one can touch it for the resources. As far as for the resources, if you have money in the bank, like investments or whatever money you have, that can be transferred through MAP. It's called the Medicaid Asset Protection Trust. And if 5 years passed, then no one can touch it. It's secured. But the pool trust comes in for the incomes.
5 years.
It's for the income.
Yeah.
Oh, but wait a minute. If it's for the income, then then a pool trust can't touch your assets. Your let's say your stocks.
It's stocks, depends. Then you have to transfer it. The better is transfer it into a trust called MAPT. If you transfer all
How do you spell that? M-A?
Medicaid Asset Protection Trust, MAPT.
All right. Thank you very much. Thank you so much.
Okay.
We are going to move on to Alma Gonzalez. Next question.
Yes, I wanted to ask about the spend down. Is it 5 years for institutional care and 3 years for home care? Or is it 5 years for both?
No. It's I'm not too sure about it. I don't want to give you wrong information, but as of now, for institutional nursing home, it's 5 years.
5 years.
But these home care, they postponed it 2023 and it's going on. So I'm not sure whether it's like 2 years, 3 years, they say, but I'm not sure about the timing of the home care. So I will check it and let you know if you are interested in getting more information about
Yes,
home
I am.
Thank you.
care. Yeah, we can touch base later. Yeah.
Yes.
Okay. And
Evelyn, I have a question on a multi-state trust. If, for example, one owns properties in multiple states.
Yeah.
Does a trust have to be done in each state separately?
No. You can do here, if you are in New York, you can do the trust in New York and transfer your asset in North Carolina, well, which I did, like we can do that. You can.
Are there any penalties for that? In other words, I specifically own property in Pennsylvania and in New York. So the properties in New York would be transferred into the trust, as I understand. But what would be, I'm not certain of what the issues would be if the property in Pennsylvania would be transferred into the trust as well. Are there penalties associated with it because it is not a Pennsylvania trust?
No, 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 no. There
No,
is no
so-
penalty for transferring your assets into your trust, right? So it's your asset in Pennsylvania and you are transferring it into your trust. There is no penalty for transferring assets into the trust. Transfer penalty comes in when you apply for Medicaid, and especially for nursing home. If you are going to a nursing home, it's called the chronic care budgeting. So as of now, they may reduce it for 2 years, but not sure. But as of now, it's a 5-year look back. So they look back all your resources and assets and income and everything. So if you can transfer it ASAP, that's the best thing. And so what the penalty means that you don't get paid, during that time. They won't, you will not be paid, meaning penalty, meaning that the Medicaid will not cover your institutionalized,
Right, care.
services. That's what this penalty means.
The other question I have is you mentioned something about being able to manage an irrevocable trust. In other words, not turning the management of the trust over to somebody else. How does that happen? Because I thought that the revocable trust is where you remain in charge of the trust. But you also mentioned that that can be done.
No.
irrevocable.
No, if you have mistaken, that is wrong. Irrevocable trust, you cannot manage because it's managed by a trustee, not you. It's the revocable trust can be managed, all 3 persons, if you are well, like, you can be the grantor, you can be the trustee, and you can be the beneficiary till you are well and alive. That is revocable, not irrevocable. Never trust. There has to be a trustee. It has to be other than you. And
Can you have 2 trustees? Or does it always have-
Sure. You
Okay,
need to
multiple
have
trustees.
a successor trustee, 2 or even 3, 4. If he cannot, handle it next, if someone predeceases you. So it's like a list of people, trustees.
Got it. That's all for me.
Okay, thank you.
Are there any other questions?
Yes, we do. We raise our hands.
Oh,
Go ahead.
sorry, I missed that.
So I have a question with this deeds, they stealing your deeds. Does the trust protect you for that? With the deed protections?
No,
It doesn't.
what do you mean by?
Well, there's a lot of scams now. They are taking people's deeds and things like that. So if I put my house in a trust, does that protect me from someone trying to steal my deed or my home?
In other words, there's people scamming people now. And
Older people, yeah.
Yeah, but I doubt. I cannot speak for that, whether it's about scams,
Okay.
This is transferring trust, into a Medicaid asset, to obtain Medicaid or things like that. So I don't know about scams. I know I cannot speak for scams.
Okay.
if you give family your assets beforehand, can the other people protest it? Like if I have 3 daughters and I give my things while I'm alive now, straight out, or sell it to one of the 3 children, can the other 2 protest it now?
No, that's, you can transfer it into the trust.
Yeah, into the
Yeah,
trust.
yeah, the whole,
Or-
one of the important thing about trust is family disharmony. So when you pass away, they cannot come back and haunt you. Or, that's one of the critical reasons why you have a trust instead of a will.
Yeah.
In wills, when you submit it to the court, there is some period, you can contest it. And I've had a contest, and then it goes on to 5 years without the will is being probated for 5 years in my experience. But in the trust, it's privacy. No one knows what's going on, and it's fully,
And they can't contest it.
yes, no
But
contest.
if you give something away before that.
But
it's
we're
up to you.
asking if you give things to your family beforehand.
Yeah.
Before the trust.
They don't, you're free, I mean, to sell or to give some of your assets prior to your dying.
Yeah, that should not,
Interfere.
yeah, that's a fair thing. That's your, what it's your assets, and you want to dispose how you would like it, so
Mhm.
only if it's a will, they will contest. Usually, if
That's
you don't have a will, it's 3, so.
So if it's in the will, you have to change you could give whatever you want now, and then you rewrite a will. Okay, thank you.
We have time for one more question. Lisa Joseph has her hand raised.
If you have that pool trust and you don't have any beneficiaries, you don't want to leave anything to anybody, and you have the pool trust, do you need to make out a will?
It was pool trust, and if you don't have any beneficiaries.
Yeah, so do you really need to make out a will? Just put all your income into the pool trust, and I don't know what happens to the assets on the pool trust. Do the assets count for the pool trust?
Because assets the best bet is for you to transfer it into a Medicaid asset protection trust or any irrevocable, it doesn't have to be said Medicaid, it can be irrevocable trust. So you don't handle it. So if you have any assets, the best bet is for you to transfer it now so that, the trustee will take care of it and it's out of your domain. That's,
So that Medicaid
asset
pool,
protection.
asset pool trust, are they taking both your income and your assets?
No, but when it comes to income, you're going to get every month, right? So it's very difficult for you to transfer whatever the money comes in. So mostly what people do is say, if I sign a trust, Medicaid Asset Protection Trust, and whatever the money I have, you transfer your bank account into the trust.
And who are the best people to go to create a Medicare?
Medicaid, I can do it if you want to do the Medicaid Asset Protection Trust.
I see.
But when
Okay.
it comes to pool trust, it's by non-profit, they calculate everything and, the monthly incomes is coming in. That's the problem with.
Oh, so in other words, if I took just a plain pool trust, that might not save me from Medicaid. That has nothing to do with Medicaid.
No. You create a pool, it's not you create a pool trust. The pool trust master agreement has already been created by the non-profit. What you do is you become incapacitated, if you are over the age of 65 and you become incapacitated, then one of your, the person who is, the agent who is representing you will join the pool trust. You don't do a pool trust. You join the pool trust which they have already a master agreement. So that's how your income, monthly income. If you have assets, you can do a MAP, Medicaid Asset Protection Trust. And right now, if whatever money you have, you can transfer everything into the Medicaid, or it can be Medicaid Asset Protection Trust, which is mapped, we call it, or specifically for Medicaid, or it can be irrevocable trust. It doesn't have to name it as a map. It can be irrevocable trust. So as of now, today, if you do it, and all the assets can be transferred into the trust, like funding. The only issue is daily monthly income. That's the problem with pool trust. Then the pool trust comes in, because if even $1, if it's over the threshold, you cannot go get the Medicaid. So that's how the pool trust come in. So you don't transfer most of your assets into the pool trust. It's income, monthly incomes and social security and pension, that sort of thing that's transferred into the pool trust. And then even that, you can try your level best to pay anything and everything that can be covered through the pool trust. Why not? Because you're not going to get anything after that. In fact, once you transfer it. So try as much as possible to get, paid your bills. And even, I don't know about clothing. Yeah, perhaps, I'm not.
All right, thank you so much.
Yeah.
So it is past 1, so unfortunately we're gonna have to wrap things up. I do just want to let you all know, I'm going to be sending out a brief survey just about the webinar and about your experience today. It's very, very short. If you don't mind filling it out, it would be extremely helpful. But yeah, we are going to have to wrap things up. Thank you all so much for coming. I hope you found the information to be valuable, and have a fantastic day.
Thank you so much. Thank you,
Thank
Evelyn.
you.
Yes. Okay. Bye.
Take care, everyone.